What's up, everybody? That was a quick break. But we have word on Judge Fisk's ruling on the motion for change of judge. We're going to go through it now. Let me give it a bit just for people to hop in here because there was no notice on this live. I didn't know this was going to come out, but somebody who follows David Gingras on Twitter sent this to me, and we're gonna go through it. So. All right, let me just pull it up. I think you guys are going to be pleased, unless you're Laura. But Laura, I didn't use that copyright photo, so. All right, what's up, guys? Let's get into it. Okay. Hopefully you guys can read that. Let me know if I need to zoom in a little bit more, but here goes nothing. Hang on. Let me take a screenshot of this as well. Give me 1 second. Okay. Try to pull this up real quick. I want to show this image, but I don't know how to. Oh, there we go. One sec, guys. Okay, you should be able to see it now. So, David posted news ruling just received from Fisk. Summary: Clayton wins again. Yawn. Basically, Fisk admits Mata's ruling contains findings that were not based on the evidence, but then says this isn't necessarily proof that Mata broke the rules. For those speculating that Mata has memorized the business hours of every PP location in America, I think it's probably not realistic. Probably not realistic, but you can't say that for sure, buddy. And this is one of the things we would have asked Mata at the hearing I requested, but Fisk denied the hearing because no reason. As you can see, that right there is my Wentworth Bandit account, so I was able to pull up these tweets after somebody sent me the document. Okay, let's see. Fisk denied the hearing because no reason. So we just need to wait for Mata to sign off on a final judgment, and then we're off to the Court of Appeals. I strongly suspect they will find these events shocking and entirely unacceptable, but who knows? Maybe the appellate court is also obsessed with reality TV stars, so he's already making claims against the appellate court, basically saying if you find against my client, it's because you're obsessed with reality TV stars. P.S. Fisk notes factual errors in a judgment can be fixed with a post-trial motion. That's generally true, except Woodnick's deadline to file such a motion has long since passed, and judicial bias is not a fixable error. So we shall see what happens. I guess we will, man. I guess we will. All right, let's get into it. The court has considered petitioner Laura Owens' notice of change of judge for cause, memorandum, and affidavit of support, hereafter the Rule 6.1 motion, and the separate affidavit of David S. Gingras in support of petitioner's notice of change of judge for cause, hereafter the affidavit, both filed 7-8, and respondent Clayton Echard's response to notice of change of judge for cause, filed 7-11. Pursuant to Rule 6.1, Arizona Rules of Family Law Procedure, the Rule 6.1 motion was referred to the Family Department presiding judge, Rhonda Fisk, this court, for ruling. For the reasons set forth herein, the Rule 6.1 motion is denied. Okay. And there's a footnote here basically talking about how Judge Mata had ruled on something prematurely and then withdrew that ruling. Now that this court has ruled on the Rule 6.1 motion for change of judge, Judge Mata may rule on the pending motions. So now she can go ahead and make her ruling. Okay. Petitioner's Rule 6.1 motion seeks to disqualify for cause the assigned family court judge, Judge Julie Mata, on the basis of bias and prejudice within the meaning of ARS 12-4095. See Rule 6.1 motion at 2. Specifically, petitioner alleges that Judge Mata purportedly did the following. 1. Performed an independent investigation into the facts of the case, and in so doing, considered and relied upon information posted on the internet about the case. And 2. Engaged in ex parte communications regarding this case with her father, Harry L. Howe, who appeared at the trial as a spectator. See Rule 6.1 motion at 1:12. Okay. As a threshold matter, this court apologizes to the parties for the delay in issuing this ruling. The court had technical difficulties opening the compilation CD included with the affidavit. When opened with Windows Media Player, the file entitled Produce an Error Message, we can't open Judge Mata's dad compilation. It uses unsupported encoded settings. Nice going, guys. With technical assistance, the court finally was able to open and review the compilation CD using VLC Media Player. After reviewing the CD, the court prepared this ruling. If only the court had Brad. 1. Timeliness of the Rule 6.1 motion. Respondent contends that the Rule 6.1 motion is time barred under ARS, and then we're just going to skip that, on the basis that it was filed after final trial and final judgment under Rule 78. This court finds that the analysis as to timeliness is more nuanced than the respondent suggests. A Rule 6.1 motion for change of judge for cause must be filed within 20 days of discovering that grounds exist for a change of judge. Rule 6.1. This court must at least consider the factual allegations to determine whether or not they are time barred. The Rule 6.1 motion in the affidavit allege as follows. Judge Mata held an evidentiary hearing on 6/10. See Example E's affidavit. Judge Mata's father, Harry Howe, attended the June 10th hearing as a spectator and spoke to other people in attendance. Dave and Megan are in this. See affidavit. Individuals Dave Neal and Megan Fox, among others, live streamed and posted on social media various interviews with people who spoke to Mr. Howe at the hearing. See it. An accompanying compilation of CD. On or about 6/17, petitioner's counsel emailed Judge Mata's division and respondent's counsel that the statements made on social media had just come to his attention and warranted a change of judge for cause. See Example 8 affidavit. At 11:58 a.m., Judge Mata's division sent a response email instructing counsel to file an appropriate motion to bring any issue to the court's attention. See Example B to affidavit. Okay, what does this footnote say? The Rule 6.1 motion alleges that these two actions separately violated Rules 2.9a and 2.9c, initiating, permitting, or considering ex parte communications outside the presence of the parties, and a judge shall not investigate facts in a matter independently of the Arizona Rules of Judicial Conduct. It is not for this court to determine whether Judge Mata has violated the Arizona Rules of Judicial Conduct. Moreover, the Rule 6.1 motion makes vague allegations of violations of petitioner's right to due process of law under both the United States and Arizona constitutions. See Rule 6.1, motion at 1:11. Again, it is not within this court's purview to determine whether Judge Mata made errors in her findings of fact and or conclusions of law that violated due process and or warrant a new trial. All right. All right, let's see. Sorry, guys, I gotta stay hydrated, you know? All right. On 6/18 at 8 a.m., Judge Mata's 6/17 under advisement ruling was filed. The June 17th ruling contained detailed findings of fact, including the following finding. Dr. Deans further testified that Planned Parenthood is not open on Sundays. When petitioner testified, she sought care July 2nd, 2023. The trial transcript from the June 10th hearing reflects that Dr. Deans did not testify that Planned Parenthood is not open on Sundays. Based on the foregoing, the court finds that the Rule 6.1 motion was timely filed. In making this finding, the court acknowledges that within 20 days of 6/17 is Sunday, 7/7. Given the circumstances of this case, including the fact that petitioner's counsel was on a previously disclosed vacation from 6/10 to 28, the court finds that the filing of the motion on the next business day, i.e. Monday, was timely. The affidavit also details various facts and rulings that petitioner's counsel alleges constitute a summary of pre-trial judicial bias. Okay. And then it says, see these examples alleging Judge Mata manifested clear prejudice and or bias early in the proceedings in the form of multiple unexplained adverse rulings. I think they were explained enough, right? Does the judge really need to explain? It's her call. The court finds that these events that petitioner contends constitute misconduct and bias occurred and were known to the petitioner more than 20 days before she filed her Rule 6.1 motion. The court will limit its evaluation of the Rule 6.1 motion solely to the two allegations identified in the second paragraph of this ruling. 2. Request for hearing. Petitioner has requested that this court hold a hearing and order subpoenas ad testificandum for Judge Mata and Harry Howe. A presiding judge reviewing a Rule 6.1 motion for a change of judge as a matter of right has discretion as to whether to hold an evidentiary hearing. This court denies petitioner's request and will decide the Rule 6.1 motion on the affidavit and memoranda filed by the parties, as well as those items on the docket of which this court takes judicial notice. Analysis of cause for change of judge. Okay. A party seeking a change of judge for cause must establish grounds by affidavit. Rule 6.1 ARLFP. One of the grounds which may be alleged for change of judge is that the party filing the affidavit has cause to believe and does believe that on account of the bias, prejudice, or interest of the judge, he cannot obtain a fair and impartial trial. The sufficiency of any cause to believe must be determined by an objective standard, not by reference to the affiant's subjective belief. God, this is all a mouthful, isn't it? Sabine Simone, thank you for the 15. Thank you for your service. No, thank you. All right. Hold on, guys. Let me make sure I just got this right. Sorry, I started this one really quickly, so I forgot to edit my description and all that. You know what? I'll have to do it later. It's fine. Okay. All right. Case law instructs that in Arizona, a party challenging a trial judge's impartiality must overcome the presumption that trial judges are free of bias and prejudice. Judicial rulings alone do not support a finding of bias or partiality without a showing of an extrajudicial source of bias or deep-seated favoritism. A change of judge for cause is not warranted if based merely on speculation, suspicion, apprehension, or imagination. That last one's important. All right. Instead, the party seeking to notice the judge for cause must prove bias or prejudice by a preponderance of the evidence. Okay. Allegation of independent investigation by Judge Mata. Petitioner correctly points out that Judge Mata's July 17th ruling contains a factual error, i.e. the transcript from the June 10th hearing shows that Dr. Samantha Deans did not testify that Planned Parenthood is not open on Sundays. See example E to affidavit. Judicial rulings alone almost never constitute a valid basis for a bias or partiality motion, State versus Ellison. This factual error can be corrected through a post-trial motion or appellate proceeding. It does not, standing alone, indicate bias. Meh. Okay. To demonstrate bias, petitioner asks that this court, Rule 6.1, motion at 7, to infer that Judge Mata's erroneous findings constitutes irrefutable evidence that she performed a secret, undisclosed investigation in the facts of this matter, because she's a spy now, and copied that finding from posts on social media. In support of this position, the affidavit includes snips of a 6/10/24 comment on petitioner's counsel's website. Planned Parenthood isn't even open on Sundays in LA, and comment posted by an anonymous Twitter user on 6/10 at 5:08 p.m. It was a Sunday, and all LA Planned Parenthood locations are closed on a Sunday. The court finds petitioner relies on mere speculation and suspicion when alleging that Judge Mata engaged in a secret, undisclosed investigation and therefore is biased. The record evidence reflects conflicting testimony about the day, date, and location that petitioner obtained an ultrasound, admitted as example B28, which petitioner admitted to altering. Petitioner testified that when she was in California on a weekend, she had an ultrasound done under a fake name at a Planned Parenthood. See example E. Before trial, petitioner had provided a declaration stating that the ultrasound occurred on 7/2/23. At trial, she changed her testimony to say it was an unspecified weekend in late June. Petitioner further testified that she had altered the ultrasound to reflect the incorrect date of 7/7 and the incorrect provider, SMIL, instead of Planned Parenthood. Awkward. So I'm just making sure that Discord wasn't anything pertinent. Okay. Dr. Deans testified that she had reviewed the altered ultrasound and available medical records to prepare a report. Dr. Deans expressed concern about the legitimacy of petitioner's medical records. Dr. Deans confirmed that Planned Parenthood's national guidelines require identification at the time of a visit to confirm the identity. I think she meant identity, not identify. To confirm the identity of a patient. The patient can't be seen anonymously. No shit. Dr. Dean's testimony did not address which days of the week the Planned Parenthood offices were open. Based on the foregoing, the court finds that when determined by an objective standard, not by reference to the affiant's subjective belief, petitioner has failed to show by a preponderance of the evidence that Judge Mata's finding that Planned Parenthood is not open on Sundays reflects bias or prejudice against petitioner. Moreover, although not dispositive of the issue, the court further finds that this singular factual finding is of little to no importance given the rest of the findings in the July 17th ruling. I mean, we all kind of knew that, but it's taken a while for them to make this ruling, so. Mrs. Brightside 15 says, Medium article is definitely coming tonight. Buckle up. I don't know. I don't think she has the balls. Plus, I think David's back from vacation, so she's not just given free reign over her weird false claims anymore. Well, I mean, technically she could, but I don't think she would go against her lawyer's advice. Omar, the Tilted Lawyer's here. He says, how soon before we see a motion to remove Judge Fisk? I would give it about 30 minutes max. No, I'm just kidding. Is that even possible? Oh, man. This is crazy. Hold on, guys. Somebody asked for a screenshot of this real quick. Okay. Allegation of improper ex parte communication with Harry Howe, a.k.a. Daddy. Look at me, Daddy. I'm a real judge now. Hee hee. I'll never forget that. Mostly because I can't stop hearing it in the Shrek gingerbread man's voice, and that's why I keep saying it like that. But, you know, whatever. Petitioner alleges that Judge Mata's father, Harry L. Howe, was present in the overflow room during the trial and spoke with several of respondents' supporters during and after the trial. See affidavit. Petitioner's counsel admits that the mere fact Judge Mata's father attended the trial, if true, is not the primary concern. For purposes of deciding the Rule 6.1 motion, this court accepts these allegations as true and finds that if they occurred, was not improper for Judge Mata's father to attend a public trial as a spectator and speak to other courtroom observers. That's right, everyone. Daddy has the right to speak to strangers in public, like the rest of us. Petitioner asked this court to infer that various statements made by courtroom observers about Mr. Howe confirm that Judge Mata was biased or prejudiced against petitioner. Petitioner's counsel acknowledges that his personal view, based on the past several months, is that Clayton's followers are generally not honest or reliable. That's a riot, considering who his clan is. Nevertheless, petitioner's counsel asks this court to find that an edited compilation of these individuals' comments about Judge Mata's father are clear extrajudicial evidence showing that Judge Mata had a hostile feeling or spirit of ill will or undue friendship or favoritism towards one of the litigants. God. Applying an objective standard, not by reference to the affiant's subjective belief, Rule 6.1, the court carefully reviewed the compilation CD and considered in context each of the comments identified in petitioner's counsel's affidavit. Given the seriousness of the allegations, the court has made best efforts to provide both the context and verbatim language of the various statements, though admittedly, the audio of the compilation CD is very difficult to understand at times. Number 1, statements by Hava Derby. Petitioner alleges that Miss Derby, also made statements which appear to imply that Judge Mata told her father that she intended to rule in favor of Clayton before the case was tried. The first video clip on the compilation CD depicts a virtual meeting among 9 participants with screen names, including one woman with a screen name, Hava Derby. Miss Derby holds up her phone and makes the following statement. I ran into Judge Mata's dad in the parking lot afterward, and I asked him, like, well, what do you think? He's like, I gotta show you something. So he whips out these papers in his hand, and did anybody, I haven't been online really today, but did anybody, I saw kind of briefly that it was denied, this request for findings of fact and conclusions of law proposed findings. Male voice says that wasn't denied. That was not denied? Okay, so anyway, did anybody get a copy of this? He was saying, Julie told me this is just you, Dad, you gotta read this, and printed out a copy. So, pausing from the reading here, guys, I'm not saying that Hava had any malicious intent here, but Hava was wrong. Bruce, if you didn't see, Bruce from Oregon, my buddy who's on a lot of my streams, he did a video confirming that he talked to the person who actually gave Judge Mata's father the printed out copy, and it was not Julie Mata. So we can confirm that that is false. And I don't think that, Hava was trying to stir shit or anything like that. I just think that she was misinformed somehow, because we can confirm 100% that did not come from Julie Mata. So, way to go, David. You're a jackass. For purposes of deciding the Rule 6.1 motion, this court accepts that the scenario recounted by Miss Derby might have occurred, though Miss Derby appears not to be clear as to exactly what she's talking about. This court finds that the fact that a trial judge might have told a family member that she was presiding over a case and might have provided a copy of publicly available filing. The request for findings of fact and conclusions of law and proposed findings. Neither proves, by preponderance of the evidence, that the judge was biased or prejudiced, nor proves that she told her family member how she intended to rule before the case was tried. Statements of Dave Neal, an individual speaking with him. God damn it, Dave. Why are you always in all these things? Dave's almost like a reality TV star at this point, right? Mama Media, thank you for the 690. Isn't justice taste sweeter than anything? Yeah. It's good. Thank you for the support. I appreciate you. You're awesome. Fancy Pants says, whoa, just got here. Please tell me this is good news. Yes, the motion was denied. We're just reading through the ruling right now. So if you're late, the motion was denied. Okay. All right. Petitioner's counsel's affidavit further alleges that individual named Dave Neal, who has hair like Jesus, and a special YouTube channel that talks all about Laura all the time. I'm just kind of summing up what David and Laura would say about him. Made remarks to signal the person speaking that they should not disclose further information regarding the comments they claim to have received from Judge Mata's father, because her believed that they would expose judicial misconduct and bias on Judge Mata's part. That is not what he said. That is not what he said. Requiring a new trial if those facts were exposed. Second video clip on the compilation CD depicts a group of people standing under an awning. The bottom left corner of the screen says Dave Neal, Rush Hour Podcast. Look at this advertising, guys. Dave's getting some free clout here. Thanks, Laura. In the foreground, there are 2 men talking, one in a red shirt. Oh, okay. You're not even going to name Reality Steve? That's fine. Foreground, there are 2 men talking, one in a red... The Reality Steve exclusion. Oh, that probably hurts, man. One in a red shirt and the other in a hat, identified in the affidavit as Dave Neal. While the 2 men are talking, a woman in a hat approaches and joins their conversation. A woman on left in a black shirt chimes in, and a second woman on the right in a black shirt follows up. I can't believe the court had to waste time on this, guys. I'm sorry. Male in red shirt. Judge Mata's dad was in the court with us. Dave Neal, male in hat. Male in hat is how I'm changing Dave Neal's contact on my phone to male in hat. That's... If from now on, if you hear me refer to Dave Neal, I will be referring to him as male in hat. Judge Mata's dad. No way. Male in red shirt. It's in the court in the side room where Judge Mata's dad was sitting there. She did fantastic. All right. Woman in hat, interjecting. I said, Harry, that's really nice. You want to be here to support your daughter. He said, oh, no. I've been hearing about this. I'm here for the circus. Group laughs as woman in hat walks away. I mean, so? That's how a lot of us felt, that it was a circus. I mean, come on. Apparently the whole family's in on this shit. So yeah, it's kind of a circus if you ask me. But that's just my opinion. I haven't been to a circus in a long time. Well, except on June 10th. All right. Dave Neal, chuckling. Ha. Hold on, we don't need a mistrial. Additional group laughter. So, yeah, he said that because it was funny. Male in red shirt, we could get him some scones. Dave Neal, yes, scones. 10 seconds of video deleted per podcast timestamp. Oh, okay. So we're leaving out some context here. I was inaudible, waiting to get in. Dave Neal, we just heard, woman on left. You don't look like the inaudible demographic. How did you hear about this case? Inaudible, my daughter. Dave Neal, there you go. Hey, that's a woman on left. And he was reading case files. Inaudible. Well, call the police. I guess David already did, but, you know. Dave Neal, I'm sure he was. I mean, he was probably a judge. I feel like it runs in the family. Woman on the right, inaudible. He did not tell me any information about her thoughts. Female voice, yes, Judge Mata's dad. And I was sitting right next to him. Dave Neal, oh, I'm sure, yeah. Okay. Good talk. God. Hey, Bruce, what's up? Bruce is here in the comments, guys. And Bruce, if you want to link to your video, Bruce, please do. Bruce has a video explaining that he did, in fact, talk to the person who provided the documents to Judge Mata's father, and it was not Judge Mata herself. So I recommend everybody take a look at that if you haven't yet. Again, for purposes of deciding the Rule 6.1 motion, this court accepts that certain facts recounted by these courtroom observers might have occurred, i.e., Mr. Howe might have informed an observer before the hearing that he heard about the case from Judge Mata. Mr. Howe might have told an observer he considered the hearing and additional goings-on to be a circus. And Mr. Howe might have been reviewing paperwork related to the case. When viewed by an objective standard, Mr. Howe's alleged statements and actions do not prove by preponderance of the evidence that Judge Mata was biased or prejudiced, or that she told her family member how she intended to rule before the case was tried. This court also finds that certain statements made by the courtroom observers reflected nothing more than mere conjecture, like Mr. Neal's statement that Mr. Howe was probably a judge. I feel like it runs in the family. Sorry, I said Mr. Neal. What I meant to say was man in hat. Was it man in hat? Hang on. Yes, male in hat. My bad. Okay. Okay. Like male in hat's statement that Mr. Howe was probably a judge. I feel like it runs in the family. The court further finds that the video reflect that Mr. Male in hat's remark, "We don't need a mistrial," after the speaker started walking away, was made in jest, as evidenced by his and the onlookers' laughter and his agreement with another bystander that they should get him a scone. The court concurs with petitioner's counsel's subjective belief that respondents' supporters gleefully celebrated Judge Mata's father's attendance at the hearing, see Rule 6.1 motion at 12, and that the supporters' actions, and perhaps even Mr. Howe's alleged actions, can be perceived to have made a mockery of these proceedings. Well, Laura Owens is making a mockery of the court, so I wouldn't take that to heart. This court declines, however, to impute bias or prejudice to Judge Mata based on statements made by respondents' supporters, whom petitioner's counsel characterizes as generally not honest or reliable, says the man whose client has a credibility problem per his own court filings. Nice one, man. About Judge Mata's father, or even statements made by Judge Mata's father himself. It is ordered denying petitioner's motion for change of judge for cause. It is further ordered denying respondent's request for leave to file a supplemental affidavit of attorney's fees and cost. It is further ordered denying respondent's request for this court to enter further orders pursuant to Rule 8.2a of the Arizona Rules of Professional Conduct. It is further ordered returning this matter to Judge Mata to rule on all pending post-trial motions. And there we have it. I said the scones thing. Oh, I'm sorry, Bruce. I thought you were Reality Steve. That's my bad. Not that I thought you were actually the person Reality Steve. I just thought male in red shirt was Reality Steve. What color was Steve's shirt? And why wasn't that in the ruling? Reality Steve called me a dumbass. Okay. All right, guys. So there you have it. That's the ruling. Judge Mana is free to go back to ruling on the motion she had already tried to rule on, but then she withdrew. I don't know if anybody here has a link to that. I know I have it somewhere, but I'm just like not. Well, I guess I could look for it right now. Let's do it. I just don't want to bore you guys with me looking for documents. Tiff kneecaps lock. Tiff kneecaps lock. Tiff is that like Tiffany caps lock? This has become one of my favorite YouTube channels. I always check to see if I miss anything. Thank you. Thank you for the 5. I appreciate you very much. That is awesome and always very nice to hear. Thank you so much. All right. Steve didn't even remember calling her a dumbass. I find it hilarious. Yeah. All right, let's find I know we have somewhere where he is or where she ruled and then withdrew. So let's look for it. Let's see. Because I remember David said it literally does not exist, which seemed a bit dramatic to me. But okay. Oh, there it is. Okay. It was this one here. I don't have a link to it here, do I? Let's see if I can find it. It's July 18th. It's got to be in my downloads somewhere, guys. Give me one sec. July 18th. God, it's been a while. Was this his blog post? I think it was. Yeah, he was very angry that day. I get that JFC doesn't care about the truth. I also get that JFC is allowed to claim that I don't know the law. That's why we have to settle these disputes. But here's the deal. JFC wants to fight this battle on social media, not in court. And JFC thinks the order today is a win for Clayton. That's absolutely wrong as a matter of law. First, the order today is void. That means it literally doesn't exist. Because Mata had no authority to issue this order while the notice of change of judge remains unresolved. And no, the notice has not been denied as of yet. Well, how the tables have turned. Okay. All right, one sec. Let's see if I can pull up that actual document. It's not that. Got so many police reports in my downloads that I can't even find this shit now. I know what to do. Hang on. Look at me, Daddy. I'm a real judge now. That came back to bite you. Or I will. Yikes. Some people complain about dead airtime on my streams, but dude, I didn't plan for this. It just happened, so. I don't think this is what I was looking for. Hey, somebody on Discord send me this so that I can stop going on a digging expedition or whatever. Love how this motion is just resulting in another judge telling Laura and her lawyer that she's a lying liar who lies, and the judge is just someone who has a calendar. Thanks for being here, Meg. I appreciate you. So with that motion denied, apparently they are now, going to go ahead with appeal. He thinks that the appellate court will be appalled, basically, but we'll see how that goes. I strongly suspect they will find these events shocking and entirely unacceptable, but who knows? Maybe the appellate court is also obsessed with reality TV stars. It's like, I dare you to rule against me. Dude, they fucking will. Like, Jesus Christ. And if you weren't here earlier, Laura Owens and her mother have targeted me personally, trying to pursue a false copyright claim against me to YouTube, which was denied. Awkward. So, you need Megan's lift music. I don't have any music, guys. I'm working on it. But, like, very slowly. Okay. Let me just pull this back up for people who have come in late while I look for this document. Sorry, guys. Let's go to the wiki and see. That's not it. There we go. The most direct way to show appreciation and support for Lauren's potty mouth. It's true, I get demonetized a lot. So the judge's boss, and thousands of random members of the public are all just wrong. Cool story, bro. Yeah, that's about how we're going here. Sorry, I'm asking for something really quick. You're going to hear thunder typing for a quick sec. I apologize for the volume of my keyboard. However, I don't have another one that's going to be any better, so. I love Twitter, and I hate Twitter. Deborah Kennedy says, I don't mind party mouth. I'm 65. It's fun and colorful. Well, potty mouth, but party mouth sounds better and honestly more fitting. So. Has Judge Mata re-entered her ruling yet? Not that I am aware of, but like this just came out. So. Okay, I think this might be it. Wait, this is not. Here it is. Okay. Okay, so this is the ruling that was entered and later withdrawn. Order entered by the court. The court received and considered petitioner's motion to vacate judgment, motion for new trial, alternatively, motion to alter/amend judgment, motion for leave to exceed page limits, filed on July 12th. It is ordered the motion is denied. And he hates when she only writes the motion is denied and does not provide an explanation. So. Sarcasm says that's angry typing. No, I'm not angry. Actually, I'm not angry at all. I'm good. Lauren, you need the wireless Apple keyboard. It's quieter than Elo on a date. I don't know anything about how she is on dates, but if it's quiet, then maybe. I don't know. I don't use an Apple though. This is a PC. So. Hey Joe says Tug is going to have a field day with this tonight. I have no doubt that is true. Bronco Fett says LO needs to move out of mommy and daddy's house and get a job. This is like one thing that I have an unpopular opinion about. I don't think there's anything wrong with living with your family, especially if you like need help to get back on your feet, or you're just like not doing well and your family wants to help you out. Like, I don't see any shame in that, especially if somebody, if say she were to get a job, but she still lived with her parents or on her parents' property for a while. Like, I don't have a problem with that. I don't think that's really that big of a deal. Like people in their 30s, they go through shit all the time, and even in their 40s, they go through shit, maybe like divorce or anything like that, and they end up moving back in with their parents. For me, when I was only in my mid 20s, but I had to move back in with my parents for a little bit, and it was like not fun, but it happens. So, but I get the sentiment for sure, for sure. Hmm. But the problem is Laura never lived away from her mom and dad. I think she didn't she though? Didn't she live in an apartment or something? And I really don't know, to be honest, because I don't care. So somebody else will have to tell me. I think it's raining. Yeah, I don't know if you guys can hear that, but it's raining pretty loud. All right. I use my Apple keyboard on my PC. It's the best. Oh, dude. Well, I don't know. How expensive is it? Because I'm not trying to pay that much for a keyboard. Sister's apartment fraudulently. Yes, that's okay. That's allegedly true, but still. Let's see, people living with their parents isn't the issue. They are a toxic mix and enable her behavior. Yes, I agree with that. But let's just be clear that that's the problem, not the living with the parents part. Bruce says she pretended to be her sister in order to live in her sister's rent control department. I think you mean rent control department in California once her sister moved to the East Coast. Yeah. Okay. Under her sister's name, so does it count and paid by who? I don't know, man. I don't know. I to be honest, I just don't care. I just don't care. As long as she leaves me and everyone else alone, I don't give a shit what she does about her living situation. So, but yeah, I hear the concerns for sure, for sure. I will forever quote Liz Neptune. Unemployment is the issue here. Yeah, Liz was somebody who was targeted early on. Laura actually called the police on Liz. The police on Liz, who was across the country here in Florida, I believe, because she didn't like something that Liz posted or reposted on TikTok. I can't even remember exactly what it was, but that was ridiculous. So, all right. Many cultures live with their families their whole lives. I'd save so much money if I didn't move out at 18. Yeah, I got you. Class of 83, Rob. Don't worry, Lauren. I don't think she has any plans to travel towards you, but she does send people to give subpoenas in Florida. I mean, I wouldn't recommend it. I'm not the one to choose for that. Like I said earlier, I've dealt with every single type of crazy, including my own. She does not scare me. If she were to try to come after me for freedom of speech, like my expressing my opinion and stuff like that, it's not like I'm saying anything that's not true and intentionally defaming this woman. She claims that I was part of a stalking, a true stalkers movement and like harassment and all that stuff. And I'm just like, dude, I have never spoken a word to you. Just stay the fuck away from me and we'll both be fine. Seriously, no one's asking you to watch this. Definitely not me. So you could try, but it's not a good idea because that's not one you're going to win. And also, it's going to be pretty embarrassing for you because I am just going to continue to speak my mind as I am legally allowed to, as is my human right here in the United States, to tell people that, yeah, you might be mentally ill, you might be crazy, but I don't believe you're insane. I think she's an asshole. So. Natalia says she has horses in Ocala, allegedly. Yeah, that's a pretty popular place for that. A long time ago, I dated someone in Ocala, and I used to drive out there, and I would see all that stuff. But yeah, that's pretty common. Pretty common. Also, Lauren, no one said that she has to be online. She can find a job in a church or as a groundskeeper, anything that's available to her. The world is her oyster. I mean, yeah, she has the means. It seems like the means, maybe not via her own income, but via her family and support and all that, to kind of do whatever she wants. I mean, we've seen it. She's chosen to exercise those privileges to abuse people with the court system. But you know, what are you gonna do? I think her reign of terror using the legal system is coming to an end here because she's been exposed for the liar that she is. So, I mean, you can only do this so many times and get away with it, right? And she met her quota a long time ago. Luckily, enough people saw through the bullshit to kind of point it out and show like how she was doing this serially, how there was a pattern. So Angelfish, is this suit against you, Lauren, the first time she has sued another woman? So she hasn't sued me. I don't know what the fuck she would sue me for. That would be the stupidest thing ever. Because what is she gonna sue me for? Saying she's not insane, right? Like, I'm not gonna apologize for that, nor am I going to pay her money. So I don't have anything for her to take anyways, right? Like, I don't own the place that I live in. My car is old and it's gonna be dead soon. My income all goes to debt. Like, I don't know what to tell her. So I would highly, highly recommend leaving me the fuck alone because it's not going to go well for her if she would come after me. David Gingras has set his account to private. That's true. That's true. So he set his thing to private a couple weeks ago. I think a while back I had followed him on one of my other Twitter accounts, and that's one that I don't really use. And I think maybe even on my personal one, but I realized recently that I was still following him on those because I was looking at tweets and it said followed by Laura Owens. And I was like, what the fuck are you talking about? And then there I was. So yeah, I have one personal Twitter account that I pretty much never use, and it's private. Then I have one that I used for just Wentworth stuff because if you guys don't know me, I make a lot of show reels for the show Wentworth. It's an Australian women's prison drama on Netflix. Highly recommend it to everybody. I go to these conventions and meet the actresses, and I get to make the videos to introduce a lot of them. So that's pretty cool. And that's where I was following him from. So yeah, but he is blocked on the only Twitter account that I really use. So there's that. Future legal defense fund or snacks. Thank you very much, Iron Rabbit. I appreciate the $5. You're awesome. I love it. Thank you. Debbie Albert, I've been following Wentworth since 70 when it was on PBS. You mean Prisoner? Like the show that it was originally modeled after? Because I haven't seen the original Prisoner. I've only seen Wentworth remake. So, or the kind of based on or whatever. Guys, I noticed a lot of people came in here late. If you're coming in just now, the motion for change of judge was denied. Let me go ahead and switch back to this tab just so you can see. Okay. Petitioner's motion for change of judge of cause was denied. And it is further ordered returning this matter to Judge Mata to rule on all pending post-trial motions. So, yeah. So Dave Mealtug and Lauren all had false copyright complaints from LO. Nearly caught up. Yep. We did. And her mother, Elizabeth Naylor is her mother's legal name. Her mother penned a letter, apparently, as well, that was included in those false copyright claims. I have requested a copy of that, but I assume it'll take a while for me to hear back. I don't know if I'll be able to get it or not. We'll see. But yeah. So further proof that the family knows exactly what she's doing and helps. So, yeah. Goosebump Netflix. What does that mean? Wonder if Megan did also. What about Snissel Ninja? I did contact Megan earlier this morning, and as far as I know, she has not received one yet. That doesn't mean she won't be getting one. But I don't think she wants to mess with Megan. That's a bad idea. It's a bad idea. Like, it's a bad idea to mess with me, but it's a bad idea to mess with Megan. Yeah. So if you guys weren't here earlier during my last stream when I shared the copyright complaint that I had against me, penned by Laura and her mother, I was mentioning that we'll be live tonight for our Quiplash stream, but before we play Quiplash, I'm gonna have Schnitzel Ninja on, as well as I think Brad will be on too, and then hopefully Bruce if he's available, but I don't know what his schedule is like. So we'll be on and we'll discuss. Schnitzel Ninja has gotten 2 copyright strikes by Laura, and if she gets another one that's taken as granted by YouTube, then her entire YouTube channel will be taken down, and that would suck. But Laura has made multiple false copyright claims. As we know, one of them was on the horse video that Schnitzel Ninja had posted. So we're going to talk to her about that. We'll see exactly what YouTube said, and we'll read any complaints that we have record of that she's filed. But just for the record, it is a crime to file a false copyright claim. So if, and I said this earlier, if she were to have anything of mine removed that would affect my income in any way, I will take her to court. So I recommend she stop this now. So that's not going to work. Cross83 Rob says Ninja can use my account. It's okay. I don't know if that's a good idea. I mean, I believe Rob has some videos now too, if you guys want to go watch his channel. I haven't had a chance to check it out too much, but Rob is someone I met when I was in Scottsdale, and he's pretty cool. So don't poke the curly-haired lady. She pokes back. Haha, love Megan Fox, even though we are political opposites. You know, I heard that Megan Fox might not even be her real name. I also heard she was in Transformers. But yeah, no, I saw the other day on Twitter, Megan was responding to somebody who's like angry over, I think it's her Karen Reed coverage. And this chick was really mad that Megan had like talked about her hair while on stream or something. She's like, she makes you donate so she will stop talking about her hair. I'm like, what the fuck are you on about? Like, people are weird, man. Laura needs to be sentenced to working in fast food. To be honest, it can happen. What? Is that's not a real thing, is it? Yeah. Amy Bonner, I feel the same about Megan. I love her to death, but I don't agree with her political opinions. Honestly, that's fine. I mean, if you love someone and they don't agree with you on some things, I think that's fine. You know, I don't agree with all of her statements either. You know, but a lot of them I do. Like a lot of them I do. So it's hard because you agree with somebody on one thing and somebody will put you in a little box and say that you fit in that box only, and that's where you are now, and they will hate you for it, and that sucks. But I don't think that's how it should be. So Schnitzel can use her Barrow login account. I mean, she has offered to give her I think it was 1 medical portal logins. So yeah. All right, guys. I will be back in like about 5.5 hours. We're going to start, I think, either around 8:45 or 9:00 p.m. Hold on. Christian, woman sentenced to work at a fast food restaurant. Oh my God, that's real. Oh my gosh. I'm going to have to watch that later. Thank you for that. All right. I'll see you in a little bit, guys. Take care, and glad that this ruling was finally put out there. So it's a good day. All right. See you later, guys.